Hello guys, good afternoon. Today we will discuss about the rules on double seal provided in your Article 1544 of your new Civil Code. So, medyo bibilisan ko lang ng kaunti. Sa mga nakikinig, you may adjust the speed of this video na lang or voice record. So, we will now proceed. Article 1544 provides that if the same thing should have been sold to different vendees, the ownership shall be transferred to the person who may have first taken possession thereof in good faith if it should be a movable property. Should it be a immovable property, the ownership shall belong to the person acquiring it who in good faith first recorded in the registry of property. Should there be no inscription, the ownership shall pertain to the person who in good faith was in the possession, and in the absence thereof, to the person who presents the oldest title, provided there is a good faith. So, the following are the rules, under your Article 1544. In case of personal property or movable property, example of personal property or movable property, mga cellphone, sasakyan, mga tables, chairs, those properties that can easily be transported from one place to another. There is only one rule, provided in your first paragraph of your 1544. That is the rules on preference in case of double sale. In case of personal property, the thing shall be owned by the possessor in good faith. Always remember that the possessor must be in good faith. Possessor meaning kung sino ang may hawak. In case of real property naman, real or immovable property. Real property, an example of which is land, o mga lupa, buildings, houses. Yung mga yan, the following rules will be observed. First is the registrant in good faith. Registrant meaning the person who registers the property in his name plus good faith shall own the property. Paano naman kung walang registration? Saan pala mare-register yung property? Provided in your Article 1544, it's your registry of property. Now your land registration authority. Kung wala namang registration na nangyari, sinong may-ari? It will now be owned by the possessor in good faith. Meaning, sino ang in possession? For example, lupa. Yung lupa may titulo. Kung sino ang pangalan ang nakalagay doon sa titulo, siya ang may-ari. Paano naman kung walang titulo? Walang titulo ng lupa. Kung sino ang nakatira or in possession doon sa lupa. For example, ikaw, binenta naman pala sa kapitbahay mo. Since ikaw ang nakatira doon, it is presumed under the law that you are the owner. Number 3, in case of there is no registration, in case there is no possession, who will now own the property? The rules provide that it shall be owned by the person with the oldest title in good faith. Kung sinong may hawak titulo na oldest title. Remember that in the case of Posuntun versus Price, the Supreme Court said that registration requires actual recording. Hence, if the property was never really registered, as when the registrar forgot to do so, although he had been handed the document, there is no registration. Okay? Always remember that the rule as to registration covers all kinds of immovables, including lands, and makes no distinction as to whether the immovable is registered under the land registration law or not. So with regards to possession naman, possession under Article 1544, possession here is either actual or constructive possession, since the law makes no distinction thereof. Okay? It can be actual or constructive in nature. Another one is that, another rule. Note that in all the rules, there must be a good faith on the person. Okay? Otherwise, the order of preference does not apply. A purchaser in good faith, okay, under the definition of the Supreme Court, is one who buys the property of another without notice that some other person has a right to or interest in such property, and pays a full and fair price for the same at the time of such purchase, or before he has notice of the claim or interest of some other person in the property. This is defined, okay, a purchaser in good faith. Okay, always remember this is defined already by the Supreme Court in many cases. Sabi ng Supreme Court, a purchaser in good faith is, okay, one who buys the property of another without notice to the defect thereof, or notice that some other person has a right to or interest in such property. Meaning, nung binenta na sa kanya, hindi niya alam na naibenta na pala ito sa ibang tao, or may naunang bumili na dun sa property. Okay? Tapos itong purchaser na to is binayaran niya na in full price. Full and fair price. Okay? Kung for example, si Pedro binenta na pala kay Juan yung lupa na binibenta sa kanya, nagbigay siya ng 50% down muna. Okay? Hindi niya alam na binenta na pala yung lupa na yun kay Juan. Okay? Then, he shall be considered to be purchased in good faith pa rin. Kahit 50% pa lang yung binayad niya. Paano kung nung pagkabayad niya nung another 50%, okay, doon niya nalaman na si Juan pala, nabili niya na yung lupa, is Pedro considered to be a purchaser in good faith? No more. Okay? The Supreme Court already defined who is a purchaser in good faith. Okay? In order that a purchaser of land with a Torrens title may be considered as a purchaser in good faith, it is enough that he examines the latest certificate of title which is issued in the name of the immediate transferor. Always remember this one. Okay, tandaan ninyo na ang isang bumibili ng lupa or isang purchaser is not bound by the original certificate of title. okay, but only to the certificate of title of the person from whom he has purchased the property. So, for example, 5 beses na palang na-transfer yung lupa na yan. Pang-5 titulo niya na yan. Okay? Hindi mo kailangang i-check. Okay? Bilang purchaser, hindi mo kailangang i-check yung mga previous na titulo. Kung pang-5 na yung nagbebenta sa'yo. Okay? Hindi mo na kailangang tingnan yung first 4. But, the law or the Supreme Court says that you are only bound to check the certificate of the title of the person for whom he has purchased the property. Kung sino lang ang nagbebenta sa'yo, yun lang ang i-check mo, yung titulo. Okay? However, in the case of Felix de Villa versus Anacleto Trinidad, okay, the Supreme Court said that where 2 certificates of title are issued to different persons covering the same land in whole or in part, the earlier in date must prevail as between original parties, and in case of successive registration, where more than one certificate is issued over the land, the person holding under the prior certificate is entitled to the land as against the person who relies on the second certificate. So, for example, yung isang lupa ay na-cover siya ng 2 titulo ng lupa. Okay? The Supreme Court said in the case of Felix de Villa versus Anacleto Trinidad, the earlier in date must prevail. Okay? Also, the purchaser from the owner of the later certificate, okay, and his successor should resort to his vendor for redress rather than molesting the holder of the first certificate. Okay? That is now the remedy of the second purchaser. Okay, another situation. In the case of Remalate versus Tibe, GR number 59514, February 25, 1988. Okay? Where the same parcel of land was allegedly sold to different persons, Article 1544 or the rule on double sale will not apply despite the fact that one deed of sale was registered ahead of the other. If, okay, remember, if the deed first registered is found to be a forgery, and thus the sale to other vendee should prevail. Okay? Always remember that the Article 1544 does not apply to subsequent judicial attachments or execution, which should be. This article does not apply to subsequent judicial attachments or executions, which should not prevail over prior unregistered sales where possession had already been conveyed by the execution of a public instrument. Okay? Also, Article 1544. Okay. The Article 1544 applies to double donation and to sales made by a principal and his agent of the same property. What is the reason for the rule on preference? Okay? Bakit nga ba merong rules sa double sale? Okay? This is said by the Supreme Court. True, no one can sell what he does not own, but this is merely the general rule. Okay? Is Article 54 then an exemption or exception to the general rule? In a sense, yes, okay? By reason of public convenience. In still another sense, it really reiterates the general rule in that insofar as innocent third persons are concerned, the registered owner, in case of real property, is still the owner with power of disposition. Another case of Karam Jr. versus Laureta, GR number L-28740, February 24, 1981. In this case, the second buyer of a parcel of land alleged that his purchase had been made in good faith because he did not know it had been previously bought by another. Question: is this enough to prove good faith in the purchase? The answer of Supreme Court: no. Okay? Because he had knowledge of the circumstances which ought to have put him on inquiry. For instance, the first buyer was already on the land when the second buyer came along. The second buyer should have investigated the nature of the first buyer's possession. Since he failed to exercise the ordinary care expected of a buyer of a real estate, he must also suffer the consequences. Next case. Illustration of rules as to personal property. Okay? In the case of Tomasi versus Villa Abrilie, GR number L-7404, August 21, 1958, the Supreme Court said that the Surplus Property Commission sold to a buyer all the movable goods in a base area in Samar. The buyer then immediately took possession of all the movable properties located within the area. Subsequently, however, the commission also sold to another the same properties in the same area. The second buyer then filed a suit to have himself declared the owner of the properties entitled to the possession of the same. What is the ruling of the Supreme Court? Okay? The Supreme Court ruled in favor of the first buyer. What is the reason? Because it was he who had first taken possession in good faith of the properties. So, sa case na Tomasi versus Villa Aprilie, yung commission, yung Surplus Property Commission, nag-advertise siya ng for sale na properties. Itong properties na to ay movable properties. Okay? Then one time, the buyer, the first buyer, immediately took all the properties and paid the same. Okay? However, the same commission, the Surplus Property Commission, sold the same properties to another buyer. Remember that in this case, the property involved is movable property. As provided in your Article 1544, the rule on double sale of movable property, the preference shall be in favor of the first person in possession of the property. However, remember, the possession must always be in good faith. In our case, okay, the first buyer immediately took possession of the properties, and there is no bad faith on his part. Hence, he is presumed to be in good faith. We now proceed to another case. With regards to real property naman ulit tayo. Anna sold the land to Ben. Subsequently, Anna sold the same land to Chito, who in good faith registered it in his name. Who should be considered to be the owner? The answer? Chito. In view of the registration in good faith on the part of Chito. Remember in your Article 1544, the rule on preference in case of real property, the first person who registers the property in his name plus the person is in good faith shall be the preferred owner of the thing sold. Another case. Anna sold her land to two different parties at different times, selling it first to Cyrus under original Torrens certificate of title. Cyrus had this title cancelled and a transfer certificate of title was issued in his name. Subsequently, Anna sold the same land under a different certificate of title to Yoyo. Which of the two buyers is to be preferred? The answer? Cyrus. Okay? This is a case of double sale, and clearly Cyrus, the first buyer who registered the land in his name, ought to be preferred. Remember, in the case of Astorga versus Court of Appeals, the second buyer of property, real estate, is preferred over the first buyer if the second buyer, was the first to register the property in good faith in the registry of deeds. Okay, another situation. Alan sold the land to Xavier, who then went to the registry of property. Xavier gave the deed of sale of registration, was given a receipt thereof, but unfortunately, the registrar, for one reason or another, was not able to actually record the deed. Subsequently, Alan sold the same land to Aiko, a purchaser in good faith. Aiko had the land registered in his name. Question: who is now the owner? The answer? Aiko, in view of the registration in good faith. Remember, the sale in favor of Xavier was never actually registered. The Supreme Court held that where a piece of real property is first sold to a person who only secures a receipt for the document evidencing the sale from the office of the registry of property or registry of deeds, and where the piece of property is later sold to another person who records his document in the registry of deeds as provided by law and secures a Torrens title, the property belongs to the latter. Always remember that the mere presentation to the office of the registry of a document on which acknowledgement of receipt is written is not equivalent to recording the property. Okay? Another case. Arthur sold a parcel of land with a Torrens title to Ben on January 5. A week later, Arthur sold the same land to Chris. Neither sale was registered. As soon as Ben learned of the sale in favor of Chito, Ben, registered an adverse claim stating that he was making the claim because the second sale was in fraud of his rights as first buyer. Later, Chito or the second buyer registered the deed of sale that had been made in his favor. Who is now the owner? Ben or Chito? Answer: Chito is clearly the owner, although he was the second buyer. This is so not because of the registration of the sale itself, but because of the automatic registration in his favor caused by Ben's knowledge of the first sale. Actual knowledge being equivalent to registration. The purpose of registration is to notify. This notification was done because of Ben's knowledge. It is wrong to assert that Ben was only trying to protect his right, for there was no more right to be protected. He should have registered the sale before knowledge came to him. It is now too late. It is clear from this that with respect to the principle, actual knowledge is equivalent to registration of the sale about which knowledge has been obtained. The knowledge may be that of either first or the second buyer. As such, in the given case, C is the considered preferred buyer. Next, another case. Between an unrecorded sale of prior date of real property by virtue of a public instrument and a recorded mortgage thereof at a later date, which is preferred? Answer: the former, or the unrecorded sale, is preferred for the reason that if the original owner has parted with his ownership and free disposal of the thing so as to be able to mortgage under Article 3344 would in such case be of no moment, since it is understood to be without prejudice to the better right of third parties. Another case. Sena orally appointed Yoyo as her agent to sell a parcel of land on September 30, 2004. Yoyo sold the land to Anna, who took possession thereof. It turned out, however, that on September 25, 2004, Sena, without informing Yoyo, had already sold the same land to Ben, who up to now has not yet taken in possession thereof. Neither Anna nor Ben has registered his purchase. Whose contract should prevail? Anna or Ben? The answer? The contract of Sena with Ben will prevail. The reason? Because he has title while Anna has no title. It is true that Anna first took possession, but it should be noted that the sale to Anna was null and void, inasmuch as wise authority to sell the land was not in writing. Another case. Anna sold the land to B and Chito. Anna sold the land to Ben and Chito with the right to repurchase. The sale was in a public instrument which was not registered, and Ben and Chito never took physical or material possession of the said land. The period for repurchase elapsed without Anna repurchasing the property. Later, Anna sold the same land to Ding Dong in a private instrument. Ding Dong was in good faith, and he immediately entered into the material possession of the land. Question: who should be preferred? Ben and Chito or Ding Dong? Answer: Ben and Chito should be preferred. The question should be resolved by inquiring as to who had prior possession. In this case, Ben and Chito had this possession, although mere symbolical or constructive, for the possession referred to in this article includes not only material possession but also symbolic or constructive possession, which can be acquired by the execution of a public document. Another case. Land was sold to Anna in a public instrument, which stated that delivery would be after 4 months. Same land was sold to Chito, who took actual material possession. Who should be preferred? Answer: Chito should be preferred because Anna did not even have symbolic or constructive possession, since the contract itself stated implicitly that possession was not at the time being transferred. Another situation. Sheila sold the land to Ben. Then Sheila became Ben's tenant. Subsequently, Sheila sold the same property to Chito. Neither sale was registered. Who should be the owner? Ben or Chito? Ben is the owner. Article 1544 does not apply because it applies only when one owner sold to two or more persons. Here, Sheila had long ceased to be the owner, for B had already acquired full dominion over the property. Next, another case. Alice sold her land to Brian, who began to possess it. Later, Carlo, a stranger, sold the same land to Ding Dong, who in good faith registered the sale. Who should be considered as the owner? Answer: Brian should be considered the owner, even if he did not register the land, because Ding Dong, who registered the sale, did not buy the land from Alice. Article 1544 does not apply in this case, since we have two sellers. Remember, had Carlo been the authorized agent of Alice, Article 1544 would have applied, for then Carlo would have been representing his principal, Alice. Another case. Amy sold her land to Bea. Later, Amy sold the same land to Carla. Bea, in turn, sold the same land to Drew, who took possession of the land in good faith. Carla, a purchaser in good faith, registered the sale of land in her favor. Question: who is now the owner of the land? Answer: Drew is the owner. The rule in the Civil Code, Article 1544, should be applied only when two buyers or more, two or more buyers bought the same property from the same person. In this case, there were two different sellers. Okay? There are two different sellers, and one of whom had long before disposed her rights as owner of the land. Another problem. At the time of the execution and delivery of the sheriff's deed of final conveyance on September 5, 1986, the disputed property was already covered by Land Registration Act, and original certificate of title pursuant to Decree 4 was likewise already entered in the registration book of the Register of Deeds of Cagayan de Oro. Could it be said that from April 17, 1984, the subject property was already under the operations of the Torrens system? In the case of Naawan Community Rural Bank versus Court of Appeals and Spouses Lumo, the Supreme Court said that yes, under the said system, registration is the operative act that gives validity to the transfer or creates a lien upon the land. Last question. Can a person dealing with registered land possess the legal right to rely on the force of the Torrens certificate of title and to dispense with the need to inquire further, except when the party concerned has actual knowledge of facts and circumstances that would impel a reasonably cautious man to make such inquiry? Answer. In the case of Naawan versus spouses, Lumo, yes, under the established principles of land registration, a person dealing with registered land may generally rely on the correctness of the certificate of title, and the law will in no way oblige him to go beyond it to determine the legal status of the property. So that ends our discussion on double sale.